Services is privileged to welcome Mr. Brian Willett. He's a double board certified attorney in both criminal and juvenile law, who happens to be one of only 10 among 85,000 attorneys in the state of Texas with this qualification. He's also the author of the book, Ignorance of the Law is No Excuse. Mr. Willett is a graduate of the University of Iowa and Memphis State University School of Law. So please give, and I'm sure he's going to tell you a lot more about what you want to hear. So please give Mr. Willett a Tarrant County College Northwest campus welcome.
Well, thank you. One of the other things too, I like to always mention this, particularly since I'm out here at the community college. I did start at a community college, so I started there and made my way up when I got out. In fact, the thing I remember the most is I think I went to summer school right out of high school, and that was probably not a good thing to do because I think I had 3 classes. I got 3 A's in it and thought, this is great. This is going to be the easiest thing ever. And then I found out, well, summer school tends to not quite be the same thing as when you're in the regular classes. So I got a rude awakening that fall when it came through. And then, of course, once I headed off to Iowa, that was a whole nother world, too, as far as getting used to it. But I'm living proof that it can be done. You can start here and you can pretty much go all the way through. And now I've been doing this for about 24 years. So it's been a while. And so hopefully you're all here because you're interested, or maybe you have a friend that has some problems. But what I will say was I like doing this part. For the expunctions, I do this speech every once in a while, or this presentation, and the reason I like it is because it's one of the few times people are actually happy to see me. Most of the time when they're coming in to see me, they're not too happy about everything. I will tell you this, you will probably get more from this, and you will probably know more about expunctions and non-disclosures than a lot of attorneys know. I do a lot of these. I will tell you that there's a gentleman down at Tarrant County who is on the prosecution side to it, and we talk all the time about it, and he is very nice about stuff. He's always will explain things, and we kind of have our back and forth about what we think should be an expunction or what shouldn't be, because there are some areas that are kind of gray. So hopefully after you see this a little bit, you'll get a better idea and see if you're eligible or if you're interested in, and then we can ask some questions hopefully. I'll go fairly quickly through this. There's some of these slides that obviously will go pretty fast. All right. What do you have? This is probably the biggest thing I have, and the question comes up all the time. It is not an automatic eraser, and what I mean by that is criminal records, they do not get erased after so much time. A lot of people I know thought it was sort of like a bankruptcy, and that if I waited long enough, things would go away. That does not happen, okay? In fact, it doesn't even happen if you go to trial and you have your case and you're found not guilty on your case. You will still have an arrest record, okay? You have to affirmatively go back to do something, and that's what we're going to talk about. Those are the couple of things that you can do with it. On a not guilty, though, of course, that's the good one, because on a not guilty, it goes a lot faster to get rid of your records. It's actually a lot cheaper to get rid of it, because there's new provisions that are put in that on a not guilty, the court has to do it fairly quickly, within about 30 days. Okay? So that's of course what you want to do with it. But you have to affirmatively do something. All right. Whoop. Kind of get your record cleared up. First one is order of expunction. That is, I would say, argued the best of the two. The second one is what they call order of non-disclosure. That one is fairly new, and I say that it's about 10 years old. Actually, it's 10 years as of this September. And that is more for cases where a person may have pled guilty to an offense, got deferred adjudication, which is a type of probation. If you live it out, it's not a conviction. And then you can go back and have your records pretty much sealed. There's still some agencies and the police, DA's office still has some access to it, but for the most part, the public record, you would not be able to see it. All right. Juveniles, just in case you want to know this, juvenile records are going to consist of anything that happens before you reach the age of 17. In Texas, the age for criminal responsibility is 17. I will tell you there's a good chance that probably anybody sitting in here is not going to have to worry about that now because you're probably older than 17, but there is a push to actually switch that age to 18. It may happen this September. If you would have asked me this 10 years ago, I would have said your chances are it would turn to 16 before they'd ever change it to 18. Really, 18 is probably a better age. There's a lot of biological studies around things, and the human brain in particular. And any woman will probably tell you this, that the male brain does not develop quite as fast. So there's a lot of stupid things we do that you really don't get till you're about 25. So I think they finally realized they need to quit being so tough on some of the 17-year-olds. All right. When can you not do an expunction? I'll start off with this is the easier one because that way you know it's just not possible. If you get a prison sentence, if you get straight probation, you cannot do that. It's just not possible with it. I will say with one caveat, there is one other exception out there. It happens so infrequently I don't talk about it, and that's you have to get a pardon from the governor. I believe Governor Perry last time, what he sat for 12 years as the governor, somewhere around there, I think he gave 6 pardons in 12 years. So it doesn't happen a lot. I know it does happen because I actually had somebody come in who said they had one. I didn't believe him when he told me. He actually brought me the paperwork. So it was kind of like the unicorn that no one ever saw, that there was actually something there. So it does happen, but just to let you do that. You can do some expunctions on deferreds if they are Class Cs. Class Cs are tickets, okay? The last one, and this one's kind of up in the air a little bit, they call it a plea and bar. And what you will do is, it usually happens with multiple cases. You'll have one case that you may plead to or you may do something with. They will say, I'm going to plea and bar your case, which means they can't go forward with it anymore, but it's also not a dismissal. So it's kind of a case that's in limbo. There's been case law back and forth. Just to kind of give you an idea, the prosecutors in Collin County will allow it. Prosecutor in Tarrant County will not. So that's why it's kind of up in the air. It hasn't been decided yet. So I just put it as you can't because it's easier to say that, because if they end up changing it to where you can, then everybody will just be happy. All right. On juvenile seals, just to kind of give you the same thing, the ones you can't do, if you get a determinative sentence, which is a little bit of a cross between a juvenile case and an adult case, you won't be able to do it. And also if you ever got transferred to an adult. So if you get certified as an adult, you won't be able to do it either. All right, expunction possibility. There's actually 6 types that you can go over, and you can see where they're at. I will tell you this, up until about 6 or 7 years ago, there was only about 2 types, 2 or 3 really. So they expanded it out, but what happened is they expanded it out, made more possibilities, but you have to watch the rules more. There's a little more rules to what you can do or what you can't do. So let's talk a little bit about those. All right, the easiest ones of all are, of course, not guilties. Anytime you get found not guilty, and you have to be found not guilty of all the charges, then you have your right to have it expunged. This particular example I give, and this one happens quite a bit, and it's also one of the cases that you have probably the best chance of winning is on a DWI case. There's a lot of them. A lot of people get DWIs. A lot of people I don't even realize sometimes that they're criminal, but they are. They're still considered a criminal charge. But they are actually one of the easier cases to win because, as I've said before, it's maybe one of the few times when you have jury members sitting in there going, oh man, that could have been me. And I certainly can relate to that. Just do it. The good part about this one too is that you have license suspensions on a DWI case, at least, that if you get a not guilty, that license suspension is also taken off your DPS record. So you get that part taken off too, which is a big deal. Because if you know anything about surcharges and you also know about license suspensions, if you, say for example, the case gets dismissed, you keep that license suspension. If you ever get stopped again, it's treated as a second one. So all of a sudden your 6-month suspension turns into a 2-year suspension, even though you were not even convicted of the DWI. It's 2 separate things, okay? It's a little bit of DWI law in there too. All right, the other one. Now this is where you kind of get it, why I said you have to do everything with it. Let's say you have a driving while intoxicated offense, but you also got caught with some marijuana, all right? So the DWI case, you go to trial, they do the trial together, you're found not guilty on the DWI, but they find you guilty on the marijuana case. Well, guess what? Because you were found guilty of one of those offenses within the actual transaction is what they call it, you cannot have either one of them expunged, okay? Neither one of them can be expunged. Now, you wouldn't get the license suspension off of that might still come off, but because of the marijuana case, you're going to be stuck, so that's going to stay permanently on your record. And that's what I put down here. Because of that, you didn't have either one. All right, unforeseen problems. This happened to me probably a couple weeks ago. Most of the time, when you get a higher level offense, they will not charge you with say if you have a traffic offense. For example, keep on going back to DWIs, but say they stop you for speeding and then they give you a DWI. most of the time the police will not give you the ticket for speeding, okay? They don't do it. There's some old rules why they don't do it, but just follow me with that they don't. Every once in a while you will see it. And here's where it becomes a problem. As I just told you, you have to be found not guilty of everything. So let's say you go in and you just pay that ticket. You just took a conviction. It's a Class C, but you took a conviction. You go, you get your DWI case. Once again, you're found not guilty. Guess what? Can't have it expunged because you were found guilty of something within that transaction, even though it was only a ticket. And you don't know how many people will go through and either take time served, or they'll pay a fine, or they'll do something. Now, if they would have done deferred with it, it would have been okay because it's a Class C, but because they took that conviction, I can't get it expunged. All right. Acquittals not guilty. This one is the other one that comes up a lot. Let's say you have a theft case. If you're familiar with any theft cases, they're graduated. In other words, the level of offense is determined by the amount that they claim that you're trying to take, okay? So, for example, if it's less than $50, it's a Class C. If it's $50 to $500, it's a Class B. If it's $500 to $1,500, it's a Class A. And then you go up into the felonies. This particular example I gave you is what they call a state jail felony, which is $1,500 to $20,000. So let's say we go to trial on that case, and they decide, you know what, you're not guilty. We don't think the value that you had was $1,500 to $20,000. But we do think the value of the items were $500 to $1,500, which is a lower level offense. Once again, you cannot have it expunged. And the reason being is because you were found guilty of something within that transaction, albeit a lower level offense. Because you have a conviction, I can't do an expunction with it. Okay, and that's the same thing I just said. All right, what's the other ones that happen? These are more felony level offenses. On the no bills, a no bill is when a case goes in front of the grand jury. You probably hear this quite a bit. For example, what happened in Ferguson, what happened at some of the other places where they say they take it to a grand jury. That's the state of Texas or whatever state you happen to be in. They present it to a group of citizens, usually somewhere between 12 and 15 of them. In order to go forward on a case, you have to have at least 9 people decide they want to go forward. If they don't, the case is called a no bill, and a no bill it amounts to pretty much a dismissal. So that's what we're talking about when we say no bills. And of course, a dismissal is just they just get rid of the case altogether. If you have a case like that where it's no billed, then you have to wait till what they call the statute of limitations, which is the time they have to bring the charge against someone to expire. Once that happens, then you can go back and have any records you have expunged, at least for the big reason. I'll get into another way you can do that too. All right, here you have a case. Credit card, debit card abuse is a felony offense. It's a lower level felony offense, but if you use someone's credit card and you're not supposed to, even if you charge $1, it's still a felony. There's no dollar limit on it. It's a felony case. So he goes to the grand jury, they no bill him, okay? So when they no bill him, in essence, it's a dismissal. But here, because the statute of limitations is 7 years, he has to wait that 7 years before he can get it expunged. Now, they vary from time to time off the offenses. All misdemeanor cases have a 2-year statute of limitations. Most felonies have a 3-year, and then there's a variation all the way up to life where you can't take them off at all, and that's going to be for cases that are more serious. All right, family violence. Family violence cases come up quite a bit. That's probably the cases I do the most of, but I do a lot of them. A lot of cases come through from here. So let's say you have a case where you set it for trial. If you set a case for trial in Tarrant County, except barring maybe two courts, it'll take you pretty close to a year before you actually go to trial. Okay, so you're sitting there going back and forth to court. You'll go to court about every 6 weeks, but you won't actually go to trial for about a year. So we're going to court, we're going to court, we're going to court. We get to the day of trial, which just happens quite a bit, and the prosecutor says, well, I don't know if I really want to go on your case. We're going to dismiss it. I'm happy, my guy's happy, except that time period between when the charge was filed and when it was dismissed does not count for your time period in that statute of limitations. So basically, they just added a year onto your time. So even though it got dismissed, even though it's been over 2 years maybe since you went, you still can't have it done yet. You have to wait. There's some waiting periods with it. And that's where it says 2-year statute of limitations. Okay. And I kind of talked about that a little bit. It's not as easy as what you had, as what it looks like, because the second part is what I was talking about. The other part is And I don't really have this come up, but let's say, for example, you do something and you think, well, maybe I ought to head on over to Iowa. That would be a nice place for me to spend the next couple of years while this case is pending. And you do that, the time you're out of state does not count. So if you think you can take off to another state, be gone, and then come back to Texas later on, guess what? That doesn't count. That time still is told for the time period. All right, weighty period expunction. This is one of the fairly new ones, and this is a great way for me to do expunctions now. This probably, I would say, probably doubled what I could do once they started doing these. In this case, they decided that this is ridiculous on some of these cases to wait so long. Like I told you, on felony cases, you have 7 years, you have 10 years, you have 28-year statute of limitations, you have lifetime statute of limitations. So in other words, you could be falsely accused of something, case was no billed, and never be able to take it off your record. And we're talking serious offenses. We're talking a lot of things like sexual offenses, ag robbery type case, murder cases, things like that. Okay, so what they did is they decided, well, we're not going to let the state just sit back on stuff and not do anything. At a certain point, we're going to say you get to clear up your record a little bit. And that's what they call waiting period expunctions. All right, what does it mean? For some reason, I don't see this a lot on Class Cs. Those are tickets. You have 180 days. If they don't do anything in 180 days, you want to go back and get your record expunged, you can do it. Okay, so that they figure if the cops can't do something within 180 days on a traffic ticket or some kind of other Class C, then that's long enough. They've waited long enough. You get a year on a misdemeanor case. Those are the Class A's and B's. If they don't do anything and a year goes by, they haven't filed anything against you, okay, you can go back and have it expunged. And on any felony offense, and this includes murder cases, aggravated sexual assaults of child, aggravated kidnapping cases, anything, if they don't do anything within 3 years, then you can go back and have it expunged, okay? So that goes from in this case, it does go from date of offense. Okay, and why I said, I think I kind of mentioned this, the reason why this is important for felony cases is because you do have some of the offenses, which if you look at here, are lifetime. The example I give is you have a person who's accused of date rape, he denies the allegations, he does a polygraph and he passes it, okay? So the sexual case is no billed by the grand jury. This is a case that happens quite a bit that I do. Normally, before he'd have to wait for the statute of limitations to run, okay? But if it goes past 3 years, then he'll be able to get his record cleared up, because obviously that's something you don't really want on there down the period. Okay? In that particular case, it would be 10 years. Instead of having to wait the 10 years, it only has to wait 3 years. The reason I call it expunction light is because the law enforcement will still have access to the information, so there's still something out there, but it's gone from all the public information. And once again, I already talked about some of this. It's a no statute of limitations, murder, manslaughter. Sexual assault on children have lifetimes. All right. Pretrial intervention programs. These things are great. I'm so happy that they've started to do a lot more of these than when it was when I first started. They didn't have a lot of pretrial things. Where you see these, at least in Tarrant County, we have one for young kids, if you're between 17 and 21 and had never been in trouble before. There's a lot of ways for me to get this dismissed. We have drug courts. We have even a DWI court. We have a veterans court for somebody who maybe was in the military, suffered from some kind of injuries or thing while they were there. We have some of those. We have mental health diversion programs, which are for things that maybe there's some mental health issues that we have. We have all these things, and a lot of these cases can be dismissed. And of course, once they're dismissed, then of course we can go back and have it expunged. Okay. A lot of times, though, what you'll see though is the expunction times, they're set by the program. So, for example, they may be a little bit different than normal, but as long as they're considered a pretrial intervention program, generally most of you can get expunged right after you're done. Okay. For example, and this is what I was telling you about, this is what we call DPP, which is deferred prosecution, at least in Tarrant County. 17 years old, he's guilty basically of burglary of a habitation, but he's never been in trouble before, including as a juvenile. Okay, if he completes his program, he can get his records expunged as soon as he finishes it. Okay, so it's right away. It's one of those things. So you don't have any waiting period with it. Okay, another example: assault, family violence. We have a pretrial diversion for that. On that particular one, they require that once you finish it, you have to have you have to have a 2-year waiting period before you can get it expunged. They want to make sure nothing happens in between that time period, but you're still able to do that, which is great because you want to get anything expunged you possibly can. All right, identity theft cases. This is kind of a tricky one, and I will tell you I know people, including in my office, who have had the wonderful, I guess, experience of having identity theft and getting arrested. And I just happened to be with her at the time that it happened. So it was even better because as I'm watching this, I go wondering, what are they doing? But, okay, you have two different kind of things with it. Identity theft, the one that can kind of happen in two different ways, okay? You can have someone, and this happens more, and I've had this happen with friends, and I've had this happen like with brothers, where one person gets pulled over, and I was worried about this. I have a brother that I worried about this with, and all of a sudden they give the name of you to the person, okay? They know all the information because if they're your brother, they know where you live, they know everything about you, and they probably look pretty close to the same issue. So the next thing you know, they get arrested, but it's under your name, okay? That is one of those where you can have it expunged because the only reason that information of your name is on there is because they gave the false information, okay? So that's kind of the difference here. If that's the case, you don't even need me for one of those because the state is required to take your records off. You have to go tell them about it and say, hey, I think this is wrong, and you need to talk to the DA that handles this, but you can have it taken off. And I don't think it costs anything to do it, okay? Okay, and this is the example that I gave. Here, you know, my guy, Joe Public is the guy in my book that I use all the time. That's why you keep on seeing that. Joe Public gets a court notice that says, by the way, you need to go to court for your marijuana case. And he says, what are you talking about? I've never even been in trouble before. I have no idea what you're talking about. But what he found out was Joe's cousin who gave all the information to him and said it was him. So what that means is somebody had already been arrested for it. So if he goes to court, generally what will happen is they'll take fingerprints and then they'll see. And I've had this happen a couple times where the person came in, they took their fingerprints, they didn't match up with their booking information, and they let them go. Or they'll dismiss the case. But in the past, before they started doing this, you could not get that taken off your record at all, which is ridiculous, I thought. And what I've always said is most of the time when these rules change, what it really means is some senator or representative kid got in trouble, and then once that happened, all of a sudden this was a terrible thing because now that it's one of my kids, it's something that needs to be done. So I'm sure that's what probably changed everything. All right. Now, where it doesn't come into play, and unfortunately this is what happened with, she doesn't get mad when I tell the story because it's unfortunate. My legal assistant, she had her identity theft, and it's kind of the same thing, and she had a check case that came out of Longview. She's never been to Longview at all, okay? She turned it in, we had all the information, it had already been documented for years. So we're driving the road, she rolls a stop sign, and she got stopped. And I'm watching, and next thing I know, she's getting arrested. And I'm like, okay, why is she getting arrested? Oh, she's got to check out of Longview. She's like, I said, she's never even been to Longview. What are you, I don't know where you're coming up with this. But somebody had written a bad check and didn't take care of it. So there was a warrant out for her, okay? Statewide warrant. So she gets arrested off of this check. I mean, and it was so bad, they didn't even spell her name right. That's how bad it was. They didn't spell her name right on the check. So it's even kind of like the salt in the injury there. But you know what? Here's the thing. She had to bond out of jail. Of course, it was a lot different because, of course, it's me, so she didn't pay any dollars off of this. But just to kind of give you an idea, she had to bond out of jail. We actually had to go to Longview and kind of fought with them. A lot of these check cases, they'll let you pay the check and dismiss it. And I'm like, we're not paying anything. It's not her. We're not going to pay it. We set the case for trial, got all the way to the week before trial before they would dismiss it. So in reality, if she would have had to hire somebody to do this, it would have cost her thousands of dollars to do this off of something that she didn't even do. And of course, now she worries about it all the time because she never knows if there's something else that may come out of here. It's been a few years since then, but just to let you know yet. And that is not an identity theft case because, see, no one had been arrested yet. So they arrested the right person. It just so happened it wasn't her that did the offense. Right? Okay, and that's what I said on the next one. All right, discretionary expunction. There are a few exceptions to where this is another one that they've added fairly recently where the prosecutor, if it stinks, then maybe they can go ahead and just take it off, okay? That's up to them. I've yet to have the prosecutor agree with me on any of these, but I think I've had a few that should have been, but they can actually have a discretionary. The example I give here is that let's say you have an aggravated robbery case, and it's based on a witness identification. But then all of a sudden, the witness says, you know what, I'm not really sure about that. I think it may have been somebody else, but the person's already been arrested. So their choices would either have to wait for the 5 years for the dismissal, okay, or the statute of limitations with it. But hopefully you'd get a prosecutor say, well, the person was wrong, it wasn't them, we'll go ahead and let you do it right now. Okay? So it's got to be a pretty good example. The one I've had before was where they did a lineup, they picked somebody out, and then they realized later on, I don't think that's the person, so it's kind of similar to that, and then you go back and get it taken off. All right. Class Cs, these are the one exceptions to where you can do deferred and still get an expunction. Okay? Class Cs, if you don't know where all the ticket offenses, there are some ordinances, city ordinances that go with it. Generally, they're fines up to $500. That's the maximum ones you're going to have. Where they become a big problem is on Class C assault cases. Okay, that's one of them that you really have to be careful with. I don't do a lot of tickets. I used to do tickets. I worked for a ticket attorney when I first started. I don't do that many now. About the only ones I ever do are if they are assaults, theft cases, anything that's kind of some of the bigger ones. A lot of times I have to worry about people with their getting their clearance. So they can't have things on their record, so sometimes public intoxication cases will come into play. But basically, they're ticket type cases. All right, two possible problems with here, and this is one of those that I get into it with my friend who is the prosecutor, that I don't agree with him on some of these, and you'll kind of see why. Okay, you probably all heard of something where you get a ticket mailed to you, okay? If you get a ticket mailed to you, his argument is you were never arrested. You can only have your records expunged if you were arrested. Since you were never arrested, you can't have it expunged. I don't agree with that. To me, that's ridiculous. If you mailed or whatever, you still have to show up for it. But that's where we have a little bit of a variation off of it. And the other one is the same thing as for tickets for family assault cases. And that'll come into play. And like I said, the ticket one, what he says is you have to have a constructive or actual arrest. So if you get stopped and the cop hands you the ticket, that's considered a constructive arrest. You've been handed the ticket. But when they mail it to you, it's not. That's where I disagree. I think that still is. The second one, and this actually comes into play a lot more, and I've actually had to start wording what I tell people a little bit, was on tickets for family violence. And the reason being is because we have a conflict between two parts of the code. One part of the code says that if you do a Class C, even if it's an assault, you get deferred on it, you can have it expunged. Okay? That's my side of the argument. There's another part that says if you do a family violence case, and this comes out of the family code, you can't have it expunged. Okay? So there's a conflict between the two. I will tell you that in Tarrant County, they still do them. That's his position. But what's going to happen, and it hasn't happened yet, is there's going to be somebody in a different county who rejects it, and it's going to get appealed up to the Court of Appeals, and somebody's going to decide which way it is, one or the other, and one of us is not going to be happy because it's going to make it where one of us is no longer going to be able to do what we want to with it. Okay? And here's just to kind of give you an idea, a little bit of information. I added this in at the last minute just to kind of give you an idea what family means. And I like this one because I don't think people really realize it. Basically, family or household equals family violence, okay? But family has a big, wider meaning in household than what you might think, okay? So in other words, you have the ones by blood, you have things by marriage, but the household one is the one that's a bigger issue, okay? It says a unit of people living together. Either they've lived together or they've lived together in the past. So if you think about this, if any of you have roommates, like say you have college roommates, for example, right? By definition, you're a family member. So let's say you get in a fight with your roommate in college, which happens. I know that one. Okay? You could actually be charged with family violence, which is crazy to think off this one that would count. And it doesn't matter when it happens. You could have been roommates from 10 years ago. If you see them and you get in a fight with them later on, that actually still fits into that definition. Now, I've never had it come up, but I always thought that was interesting that they would be able to do that. All right. Orders of non-disclosure. This is what I kind of call, it's more of a seal. It's very similar to a juvenile seal. Order of non-disclosure didn't happen until 1995, so that's why I said it's about 10 years old now. And what that is, that's for things that are deferred adjudication. If you know what deferred adjudication is, it's a type of probation. Yes?
Yes, may I take a picture of that? Or no?
Yeah. But deferred adjudication is when you actually can plead guilty or no contest to a charge. The judge says, I find there's enough evidence to find you guilty. I'm not going to find you guilty. I'll put you on probation for a period of a year, 2 years, whatever, all the way up to 10 years. And if you live that out, at the end of that time period, I can dismiss your case. That's what we're talking about here. Okay? Now, there's some offenses you can't do it on, and there's some offenses you have a waiting period. Yes?
Deferred adjudication still shows up on your record?
It is not a conviction. There's still an arrest record that's always going to be there until you go back and do something with it. Okay? But like I said, there's some offenses you can do it for. There's some that have waiting periods. There's some offenses you can't do it no matter what happens. And there's some kind of decision with it. Yes?
Follow-up question would be that. But can you answer no under having to plead guilty to a charge?
You can answer no. Have you ever been convicted?
We can't plead no to...
Well, okay. So, and every once in a while, the questions, it all depends on what the questions are, because they've gotten a little more sophisticated as what they ask. Because if the question is, have you ever been convicted? Your answer is no. If you do deferred, it's no. You have not been convicted of anything. But the question they will ask now is, have you ever been arrested? And that's a little bit different. So if you've ever been arrested, then it'll come through. And actually sometimes, and I will tell you this, you do not have to answer this. They will actually ask the question, have you had your records expunged? Okay? You don't have to answer yes. That is not something that you have to answer by law. So, and there's no way they would know, because if it's expunged, they're not going to be able to see it. So I think what they're doing, they're trying to call your bluff. So they're kind of bluffing you to see if you'll say it or not with it, okay? All right, so what do you have? Misdemeanor offenses. The ones that you're eligible for, generally you can do right after you finish it. For example, like a theft case, there's no waiting period off it. So if you get a 6-month deferred probation time, you can start that right away. There are some offenses that you have to wait a 2-year period. Generally, they're you can kind of see the offense that would be there. For example, public lewd, indecent exposure. You have to wait till 2 years after that. Assault cases, weapons cases, those kind of things, they do have some waiting period with it. The one things you can't do on, though, if you look at this, and I put it down, generally anything that has to do with family violence, you can't do. So that can include things like violations of protective orders, interference with 911 calls, interference with children, things like that. You won't be able to go back and do it. All right. The example I gave here, okay, he's got deferred adjudication, and this can be a problem too. Got a theft 50 to 500, completes it. Same thing, this one actually is the one where you can do it. So as long as he completes everything, he's eligible right away once the case is dismissed. Okay, felony cases, they actually take a little bit longer. If you're eligible to do that, you have to wait 5 years. When they first started this rule, it was 10 years, okay? I know the 5 years sounds like a lot, but compared to 10, it's not so good. And the reason why that was such a big deal is, let's say you were 20 years old and you got a 10-year deferred adjudication. That meant you had to wait the 10 years that you were on probation and another 10 years before you could even have it taken off, which means that you went from 20 to 40, which you pretty much just lost the biggest part of your working career anyway. So they decided they were going to cut that down. So that's one of those things where I always try to get the lowest, if we're going to do deferred, the lowest amount of time, because if it's something that's the person's eligible, I want them to be able to get it taken off the record pretty quick. I'm hoping that will be one of those rules that somewhere in the near future they're going to go ahead and reduce it down a little bit to maybe not so long. All right. Same thing for the example I gave, burglary of a building, that's a state jail felony. Got a 3-year deferred. He actually has to wait 8 years, 3 years till he finishes the deferred, 8 years from the time he finishes. All right. This one is one that came up, and it can be a problem sometimes when you get multiple offenses. Let's say you get, or different counties too. Let's say you have a check case, and you live somewhere. We live here. We live kind of on the border of Dallas and Tarrant County, so that's not that unusual. You go to different places. So let's say somebody writes a bad check in Dallas County, they write a bad check in Tarrant County. If you didn't know this, it goes to each county. You have 2 separate charges. You have to go to and have court dates at each one of those, okay? So you're going to do that, and even if you have the same attorney. So let's say we go, and I got them worked out. They're going to let you do deferred on both of those cases. So we go to Dallas County and we plead that case out for deferred. 3 months, something really short, 90 days worth of deferred. Okay? Very next day, we go over to Tarrant County. We plead that case out to that same 3 months deferred. Okay? Because you were already on deferred in Dallas County and you picked up a new offense, I can't take that Dallas County one off your record now. You can still do the Tarrant County one, But you can't do the Dallas one because while you were on deferred, even though it happened at the same time, they go by when you actually get deferred, you went on deferred on a second offense, okay? So I can't do it. And where that becomes a problem, and I won't say who the judge was, but we'll get misdemeanor and felony cases. The rules, if you don't know this, on misdemeanor and felony cases, you can move a misdemeanor case up to felony level to take care of it. You just can't move a felony case down to misdemeanor. So a lot of times when we plead cases out that have multiple cases, we'll pull the misdemeanor case up with it to felony court and take care of them all on the same day. So if you get deferred, you're fine. You pled them on the same day, everything was taken care of. But some of the judges will get mad about doing that because they feel like they're doing the misdemeanor court judge's work, so they don't want to do it. So they make us go on another day. Now I generally, if I have to do that, will try to take the person, I'll go down to the court and say, hey, I pled this case out, I want to get rid of this other one on the same day. And this is part of the reason why, because if they ever want to go back and get things taken off, I don't want to screw it up for them to where they can't do it, okay? All right. Let's see here. That's just kind of what we talked about. All right. Same thing now. Order of non-disclosure is a little bit different because it's not as good as an expunction, okay? You still have, the police have access to it, the DA has access to it, and there's some licensing agencies in Texas that still have access, so they'll be able to see it. Doesn't stop you from doing anything. For example, the law examiners have it, doctors, nurses, there's a bunch of other places. The ones you think of, if you're licensed within the state of Texas, they probably have access to it. It doesn't mean you can't do that, it just means that they're going to be able to see it, okay? All right, certain things you can't have, or if you've already had a conviction of it, obviously they're kind of big things. If you were ever registered as a sex offender, they're not going to let you have an order of non-disclosure. Aggravated kidnapping, murder, injury to child, violations of protective orders, stalking cases, or any kind of family violence. Okay, you can't go back. Yes?
Can you tell me, so that I'm understanding why you're talking about the difference between an order of non-disclosure and expunction?
Because on an expunction, it's gone from everybody. The police will not have access to it. The DAs do not have access to it. Everything's wiped out. With the order of non-disclosure, they still have access. If I look it up on a public record, you won't be able to see it. But they will still have it. And the reason being is because they look at it this way. If we gave you a deferred, which is kind of a second chance, then we're going to know that next time, because if you get in trouble again, we're not doing it again. Whereas in theory, if you could get every case dismissed or not guilty, you could keep on doing the things they would never know about it. I mean, unless they personally knew you, I guess. But it'd be one of those where, as long as you got it expunged, as far as they know, it's a first-time thing.
So for the purposes of jobs and
Yes.
and things, the non-disclosure is good.
It's good, but it's not as good as an expunction. You always want a dismissal or not guilty if it's ever possible. Yes.
Are these expensive to have done?
Yes. They're pretty expensive for the most part. Let me finish. I just got a couple more, and then I'll kind of go over that too. And I'm glad you asked that, because no one ever asked that question, except I do when I go to seminars. But okay. All right, juvenile seals. I just want to do this real quick because if you're younger, you may be wondering about this. Juvenile seals, basically, I do a lot of these too. They're kind of like an order of non-disclosure. Pretty much, if you're found not delinquent, you're never found criminal. Just so you know this, a juvenile record is not a criminal record. So if they ever ask you if you've ever been arrested, your answer is no, because they don't arrest you in juvenile law. They detain you. If they ever said, have you ever been convicted? Your answer is no. You're adjudicated. So anything that stays in the juvenile court is not a criminal record for the purposes of any of your questions that you ask, okay? So just keep that in mind if you ever had anything. Now, the bad part is they can use them against you in the adult court to enhance your charges and do some other things. So you want to, even though they can't use them for convictions, they can use them to enhance you, okay? Some of them you can do right away if you do first offender, supervisor caution, the DPP for juvenile you can do right away. If you do a determinative sentence, you can't. That is the one exception where you can't have it sealed. All right, misdemeanors, basically it's 2 years from the time that the case is dismissed. Felony cases, you have to be 19. Okay, so at 19, that's where you can get your record sealed. And then finally, and this will end up on that one. All right, look this up. This is from a thing called the Society of Human Resources and Management. And they said, what kind of jobs or what do you do not hire someone? What percentage would it be? And 96% of the people said if you had a violent felony on your record, they would not hire you. 74% said if you had any felony record on your record, they would not hire you. So that's why it's important to go back. If you saw my brochure, if you figure it out, and I think I actually probably use low numbers with it, if you look at the difference between about a $35,000 a year job or a $50,000 a year job, I mean, over your lifetime, you're talking about $750,000 in income that you lose out on. So it's important to get rid of them when you can. Now, to answer the question, they are very expensive, and it's probably the thing that keeps a lot of people from doing them. I don't really have a good answer for you because it's just the nature of what it is. I would say for an expunction, it's going to vary a little bit depending on the county and what's involved with it, but you're looking at probably somewhere between maybe $1,200 to $1,500, okay? Which is pretty expensive, particularly if you don't have a job to come up with $1,200 or $1,500. But part of that, and this is probably the biggest part with is, it's about $400 just in court costs. And the reason being is what's involved with it is that you have about 8 or 9 agencies that you have to send things to, and you have to send it certified mail. If you've ever sent certified mail, you know it's about $7 a piece. So you've got to send them out. What happens is they get the information saying that you want this sealed or you want the expunction done, and then they have 30 days to challenge it if they think, hey, this shouldn't be taken off. I don't know what you're talking about. These records are wrong. They don't do anything. The court will set you a court date, usually somewhere 6 to 8 weeks or so is generally what it takes. Once it's granted, then you have to mail them back certified copies of the fact that it's done. So now this is your second set of certified mail. And then they actually give them 30 days to seal up their records from there, or destroy or whatever they're going to do with it, okay? So if you see, it takes about 4 months to get everything through. But a lot of it ends up being the court costs with it. So roughly, in case anyone, if you've never had some idea, I like doing this. I'm glad you asked that question because I always get these things with expert witnesses where I'll go to these seminars and they'll say, well, you should get this expert witness, you should get this expert witness. And finally I said, well, how much is this going to cost? I mean, because you know that you do have to look at that off of it. Just to kind of give you an idea, if you did a misdemeanor case in Tarrant County, Dallas County, usually you're going to, in attorney fees wise, you're probably going to spend $1,000 to maybe $1,500. To me, 15 is kind of high, but let's just say from there, okay? All the attorneys vary a little bit. Felony case, yes?
Do you have to hire an attorney, or is it something you do?
For this?
Yeah.
Well, I would say this. You can always do it yourself. I mean, it never stops you from doing it. The problem is, and this is what I would say with it, if you mess it up, you pay for the court costs, and if it's wrong, guess what? It doesn't come back to you. So I guess what I would say is you're going to spend $400. Hopefully you do it right, that's fine, but if you do it wrong, you just wasted $400. So is it better just to make sure it's done right and you have it right? I mean, that's kind of a decision you have to make with it. But it can be done, yes.
Is that off each one, or is that for a record?
It'll depend on, you can do multiple cases if they're within the same transaction, but if anything's on different dates, then you have to do them separate. Because what happens, or if they go to different agencies, because then you have to send to each one of those off of it. So usually you can do, if you had a DW case and a marijuana case together and you're found not guilty on both of those, generally you can do those together. But if you had a DWI and then 3 weeks later you got a burglary of a vehicle case, no, then they're separate, so you have to do them. Yes?
Back to your friend who works for you. Did someone steal her identity and create a checking account, or how did they
They had her driver's license number. How, she has no idea. But they had her driver's license number, and they like I said, they didn't even, when they signed her name to check, it was at Walmart, and when they signed it, they didn't even sign her name right. I mean, they misspelled her name off of when they actually signed the check, but she still got arrested for it.
And then my second question is, how do they mail you a ticket? I mean, if you're getting a ticket, the officer's in front of you.
Well, where you'll see them sometimes,
Oh, okay.
for example, let's say you have an assault case, and I'm not going to pick on the guy all the time, but the guy leaves, right? And he's going to get charged with assault. And they decide, well, this is going to be a Class C assault. We don't think there was any bodily injury, but there was some other contact with it. So he takes off. Well, he's not there. So what will happen is they will mail you a ticket saying, by the way, you just got charged with assault. Or sometimes they'll do it on theft cases too, where they may let you go, but then Walmart will send you a letter, not Walmart, but the police will send you a letter saying, by the way, Walmart told us you stole something, we got you, we're sending you this ticket for it.
So you could be somebody could have misinformed and sent
Yes.
a ticket to somebody who didn't do that. And then
Right. Well, that's even another problem, and that's a whole other set of problems. But yeah, that happens.
Oh my gosh.
Yes?
So the DWI cases, some cases could be, have an order of disclosure or deferred, well,
No, you cannot, on a DWI case, you would never be able to do an order of non-disclosure because there's no deferred for DWIs, which is the craziest thing of all. You can be a sex offender and get deferred. Now, you couldn't get it on that either, but I'm just saying, you can get deferred on a sex offender case, you cannot get deferred on a DWI. It's like the only offense.
or expunged either.
No, you get expunged if you're found not guilty.
Okay.
But I mean, it's just weird that of all the offenses, which is, and I will tell you this too, if you've ever, DWIs are the biggest money-making generation things that they have at the county. You will get charged more on a fine, your court costs are more, everything about a DWI is just, and it's because normal, I don't want to say normal, but you know what I mean, everybody can get a DWI. I'm just telling you this right now, if you drink it all and drive, you are always taking a chance. It doesn't matter how much you had, there's always that chance. Because by definition, the DWI is loss of normal mental or physical faculties. That's an opinion, okay? That's somebody's opinion, so you always have that chance. Yes? Back further. Yeah.
So, like, in other words, that's a way for them to protect,
To what?
like, to get money from the community.
Well, they won't say that. That's what I would argue, but I'm just telling you because it varies a lot. But I will say this: it's the best case if you're going to try a case. You should always try this. This is what I tell everyone all the time. The offers that I get on a DWI case, and I know this is going off subject here, but the offers I get on a DWI case are basically the same thing you get if you go to trial. So there's almost no reason not to go to trial because you're not going to be punished anymore by going to trial for the most part. How you get punished is this: you end up going to court a bunch of times, and you got to pay for a trial. So, for example, if you came to me and wanted to do DWI to do a plea, I may charge you $1,000. If we set it for trial, I'm going to charge you $5,000. So that's where you get punished. They punish you one way or the other, but the cost involved with the DWI will be $8,000, $9,000, $10,000, even if you plead out to the case. It's crazy.
The traffic tickets where they take your picture and mail it to you, like red light tickets?
Yeah.
How do you know who's driving?
Well, that's a whole nother thing, and this will be from my personal experience because I've had a couple of those red light ones, you know, where you're there, and I went in at first and argued with them about it too, because for one thing, my car does sometimes get driven by people at my office, and I think I was actually in court. And they gave me the ticket because it was registered in my name. And I said, okay, well, I want a trial. And they're like, well, you don't have a right to a trial. It's administrative. So it's not criminal. It doesn't count as points against you. It doesn't count. And what they do is, I think that's why it's like $75, right? I think that's because it's just enough money that you're gonna pay it, but you're not gonna waste your time going down there and sitting for 2 or 3 hours because it's a pain in the butt. And it's certainly not worth it for me, but I hate that. I think I've had 2 of those, right by my office too. From doing the little red turn, right turn, you know.
You put not guilty and just pay it?
It's not criminal.
Oh, you just pay it, period.
Yeah, just pay it. I'm like if you watch Liar Liar, do you remember does anybody know what part I'm talking about, where he got his car scratched? You know, and they said, well, what are you going to do about it? He goes, nothing. I'm going to sit here, I'm going to bitch and whine about it, and then I'm going to bend over and take it. He goes, oh, you've been here before. So that's what you do with them pretty much, because there's not much, it's not worth it. It's not worth your time to mess with it.
But your insurance goes up, right? Your car insurance.
I don't think so. I don't think they counted. I don't think they do it. What they will do though is, I think if you don't pay them, they can end up suspending your license, and that's how they get you to pay them. Yes.
Anything you've been convicted of, you can't have expunged.
You cannot have it expunged. The only way, if you have a conviction, is you got to get a pardon from the governor. And this is even weirder. I didn't even mention this because it happens so infrequently. If you have your case and you're found guilty and you appeal it up, and they reverse the case and say, you know what, we don't think you're guilty. We think they made the wrong decision. It's still only discretionary to get your record expunged. The court has to agree to it. In other words, even though a higher court said you are not guilty of this offense, expunctions are only for trial level offenses, so you have to go back down, and the judge would have to agree to expunge it still. So if you had a jerk of a judge, he could actually stop you from getting expunged even though you were found not guilty. Yes?
If you get a DWI, if you're arrested for a DWI, and you want to plead no contest or not guilty,
Right.
but they take a breathalyzer and you're above the, point.
Legal number?
How does that play out?
How do you fight it?
I'm sorry?
You mean how do you fight it?
Yeah, how do you
Fight that?
fight that?
Because here's what I will tell you. I love this. This is like doing a DWI Poor Dyer. Okay, when they give you the definition for DWIs, it says there's 3 ways you can be considered intoxicated, okay? Loss of normal mental faculties, loss of normal physical faculties, test scores of 0.08 or above, okay? What it doesn't say on that last one is it doesn't say test score of 0.08 above based upon the intoxicators or 5,000 machine. In other words, there's errors, there could be errors within that machine. Not everybody, the way they measure everybody out, it measures by your lung capacity and some other things with it, just to kind of get into science a little bit. Well, everybody's different. Everybody's lung capacity is different. And just to kind of give you an idea, and you'll love this, women will tend to test higher with the same amount of alcohol than guys do. Okay? Because part of it is your body fat content, and since women have typically have a higher fat content than men do, they will keep alcohol in their system longer. So they tend to test a little bit higher with it. Plus they base the test score, I think it's on the size of who they usually think of is a guy that would be, I want to say it's 5'9", 5'10", 160 pounds. That's what they're basing on. So obviously people vary from there. In fact, it hurts you the better shape you're in, it also hurts you. Because then your lung capacity and stuff is bigger and you're in better shape and stuff gets through your system better, so that will actually test higher. But I will say this, anymore, they're doing probably more blood tests than they are breath tests anymore. That comes up quite a bit now. So
This might be getting ahead of the cell phone thing that's going on, but to me, I see that texting while driving will become parallel to or reflect DWI. Like in school zones, you watch people do not text. $200 hurts if anybody's driving through there.
well, I think the study they've had is it's just as dangerous.
Yeah, well, I'm just wondering, like, if it doesn't.
I don't know if it'll ever go that far. The problem I have with the texting and driving one, and just to kind of give you an idea, is like if I'm going somewhere and I'm using my GPS on my phone, I'm still looking at, but I'm not texting. I mean, but that's what I'm looking at. So I don't know. I've always wondered if you got stopped and you said, "Hey, I wasn't texting. I'm here. Here you go. I'm looking for an address."
Right, and
So.
then if you have the car with the GPS, you're looking at that screen.
Right. So not yet. They haven't got there yet. But it's every. In case you wondered, the legislative sessions in Texas only happen every 2 years. They don't meet all year round, and it happens every September, and it's on odd years. So this year is a year when the new law changes come through. Okay. Anything else? Yes. Okay. Okay.
I'm not real familiar with any of these processes, but
Huh?
when do we call a lawyer, like in a DWI? When should
Well,
we call a lawyer?
you need to call them right away because it never helps to wait. On a DWI in particular, you want to call because there is some arguments you can make for fighting your license suspension, but you have to do it within 15 days.
15 days?
15 days from the time you get the DWI. So that in particular is a reason why. But generally speaking, you always want to call them right away because there's other things you can do. Sometimes I have cases that if I catch them early enough, when I was talking about the no bill part, they'll let you make presentations sometimes. So I may have a case where I think shouldn't even get to court. So what I ask them to do is that I can make a presentation in front of someone. This happens a lot in sex cases. So you get somebody accused of a sexual offense. I make them go in and do a polygraph test. If the polygraph test comes back good, obviously, I take him into him and say, see, my person's telling the truth, they didn't do anything. A lot of times if you take that to the grand jury, they'll dismiss the case right then. They'll just no bill it. So that's why you want to do it right away. Yes?
A follow-up question to what she was asking, at what point in the conversation with the police officer do you tell them, I don't want to talk to you, I want to report?
Okay. On the DWI, this is a weird one, and it's funny.
Like regardless, like you were saying, a sex case, like, a cop comes to your house, hey, Billie Jean called in and said that you touched her or whatever.
Well, first of all, if you get accused of a sex case, you don't want to be talking to them, period. And I'm not making light of it all, but you really don't. If you voluntarily go in and talk to the police on stuff, so many more things can come in. You don't want to do that. You always need to. Now, on a DWI, it's a little bit different because here's why. On a DWI, their preliminary questions are not considered testimonial. That means that they can't make you answer them, but they can answer. They can ask you things like, where have you been? Where are you going to? How much did you have to drink? To me, how much you have to drink goes too far, but the courts have said that's okay. They can ask you to do field sobriety tests. Same thing, ABCs, counting backwards, all whatever the things are. That's not considered testimonial. That's just considered, it's routine questions off of it. So they can ask you things like that. Where you want to quit answering questions is they'll take you back to the station. Then they start asking questions like, were you operating a motor vehicle? Okay, now that's getting into incriminating because that's one of the things they have to prove, that you were operating. So that's where you shouldn't talk anymore. Unfortunately, people generally will start talking there more than what they were before, and they answer all their questions. And where it hurts you, and just one little DWI thing. Anybody who thinks that the best answer to give the police officer, when they say, when did you have your last drink? And you say, I didn't have a drink for 3 hours. And then they take your breath test score and it comes back 1.5. Guess what that means? That means you had 2.5 hours to have your blood go down, so they're thinking it's higher than that. So really the best time to answer is, I just had that last drink about 5 minutes ago. Because that way there's some room to play within that number a little bit. So telling people that you had it a long time ago is not in your best interest. It's actually to say it's closer to the time. Okay?
So felony and misdemeanor convictions are eligible for expunction?
It depends what happens. If you're found not guilty, or if they get dismissed, or no billed, yes.
But not a conviction?
Not a conviction. Yeah, conviction is bad for all the way around.
I had a question on the tickets. Okay, I got some tickets in 2005 in Fort Worth, but I'm pretty sure I got arrested and I got the tickets, but I never physically got the tickets, but they're still on my record. But you said if they don't do something within 180 days, like, as in go to a warrant or what?
Well, they have to have it filed. Tickets, you don't really see that as much. That's why I don't see too many Class Cs with it. The problem with some of the tickets is it takes them years to get to court sometimes.
So it's still out there. I still need to take care of it.
And I will tell you this too. Have you moved at all?
Probably, but
Well, you need to check with them, because here's the thing: when they take your address off of your driver's license and you move, they don't forward it to you. If you don't get it, that's too bad for you. So you have to keep up with all that stuff. If you move from one place to the other and you have something pending out there, make sure you follow up with them, because next thing you know, you'll get a warrant.
Yeah, because see, it's for no insurance, and if I plead guilty to it, even though it happened in 2005, I'll have to do the 3 years surcharge.
Exactly. Yeah, you need to have at least deferred. Whenever you get tickets, for the most part, you always want to make sure you get deferred with it, because if you get 2 of those no insurance ones, they also suspend your license.
Yeah, I mean, I'm doing the no insurance surcharge fees now.
Right.
So if I plead deferred, then it won't.
Yeah, deferred is not
They'll give me time served, but that's pleading guilty.
Yeah, no, you want deferred. Deferred is not a conviction, so that's what.
I can do that.
Right. Yeah. It will generally no. Actually, no, you don't. Generally on tickets, you always want to try to get deferred if you can, because those don't really go against you then. So whatever you do, just get deferred. Just always make sure after that.
You have to pay the ticket and get deferred, right?
Yeah, you still got to pay, and it usually is a little bit more. Like, for example, an insurance ticket may be, if you pay it, they may charge you $275. But if you do deferred, it may cost you $350. But what I'm going to tell you, in the big scheme of things, you want to pay the $350 because you want it deferred. It's going to cause you more problems if you don't.
Thank you.
Okay? Yes?
Well, like we were saying with the DWI, like I refuse everything, blood, everything. They didn't give me the blood, they forgot about me. But my lawyer actually says, he wrote out the little VHS thing. He says, here's you stumbling. They can pull up anything from the car and the jail. They can pull up anything. They see you stumbling, if you go to court, they can say, he's stumbling. And the DPS certified, so you're guilty pretty much as is. And then they told me that, and I went in there without a lawyer, and they said, we can arrest you without having a lawyer now.
Well, that's not true. But here's what I'll tell you. DPS, you know what DPS certified is? DPS certified means they did 24 hours in a class. I'm DPS certified in field sobriety tests too. Okay? It's nothing. It's not like they spent years and years off it. When you do the certification, they basically, you go until you pass it. No one ever fails DPS certification. And I ask that question all the time. I said, how many people in your class failed it? 0. No one ever fails it. It is not as big as what they try to make it sound. So, yeah. Yes.
This is about tickets. If you have had traffic tickets and when whether you did community service or you ended up paying the ticket or
Right.
give it to an attorney or whatever.
Right.
Well, no, scratch the attorney, just, could you still take those off of your record or they stay?
Well, here's what I will say. For the most part, tickets, I mean, the only kind of tickets I would ever say you want to take off your record is assault cases, maybe PI cases, and theft cases, okay? Anything other than that, if you get a speeding ticket, no one, I don't know any job, unless maybe you're going to be a driver, that might be the exception to where you might want to, but no one's going to sit there and say, I don't know about her, she's got a speeding ticket here, I better not hire her. So I wouldn't, to me it's not money effective. I wouldn't think it'd be worth the money to do it. So I wouldn't waste my money off of doing
What
that.
about when it comes to like the surcharges and stuff like that?
Well, sir, if you do deferred, you're okay. It's on convictions. That's why I'm saying you always ask for deferred, because the surcharges things only apply when you get too many convicted tickets where you just pay them. Okay? So make sure you do them deferred. That's why it's such a big deal.